Hi everybody, my name's Griffin Bridgers. Today's video is about partnership interests and community property and how the two intersect when it comes to basis determination purposes, especially where a step up in basis may be involved. And we'll look at how you fill in some gaps in tax law under Revenue Ruling 79-124. Now, before we get started, I want to remind you this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. So, if you don't know about community property, it's typically a right that is granted to property acquired during the marriage of a couple in certain states, usually the Southwest and Western states. I won't dive into which states those are, but the outcome is that regardless of titling, community property is deemed to be owned one half by each spouse. And for tax purposes, this special status, this deemed one half ownership by each, creates some unique benefits, especially if a spouse dies. Because if a spouse dies, they typically only have to include their deemed one half ownership of the community property in their gross estate. And there's a step up in basis rule that typically applies only to the property included in your gross estate. I haven't listed that out here, but that's Code Section 1014B9. However, there's another code section which complements this, 1014B6, which says the other half of the community property that's deemed to be owned by the surviving spouse is treated as if it's acquired from the deceased spouse at death, which means that both halves of the community property get a step up in basis, even though only one half is included in the gross estate of the deceased spouse. Now, I'm splitting hairs here because a lot of people assume that this step up in basis rule applies in all circumstances, but there's one technical requirement that we have to get nitpicky over that's a qualifier for all of 1014B, and that's that property has to be quote-unquote acquired from a decedent. Well, the catch here is that the spouse's one half was already owned by them, the surviving spouse's one half. They didn't acquire that technically from the decedent, but they still are deemed to under this 1014B6 rule, thus meeting the requirement for this step up in basis. So the catch here is that at least one half of the community property has to be includable in determining the value, quote unquote, of the deceased spouse's gross estate. We'll talk about the significance of that and whether that's a rabbit hole towards the end of today's presentation, but the outcome here is that this results in technically one half of any asset being stepped up under 1014B9 and the other half getting stepped up under 1014B6 if that asset is community property. So how might this apply to something like, say, a partnership interest? Well, in a partnership, this means that you would step up both halves of the outside basis of a partnership interest. Now, the problem with the step up in an outside basis of partnership interest is that it doesn't affect the inside basis of partnership assets. So if partnership assets are sold or exchanged by the partnership, those can generate gain, which is still then recognized proportionately by the partners, including those with a stepped up basis, even though they technically shouldn't have to recognize gain on growth in the inside basis of those partnership assets, or the inside value of those partnership assets, I should say, that accrued during the decedent's lifetime. And you can get around this through what's known as a Code Section 754 election. So this election is authorized by Code Section 743 anytime there is a transfer of an interest, either due to a sale or exchange, or in this context, upon the death of a partner. But here's the problem. With community property, there may not be a transfer of an interest for the whole partnership interest. Only one half that's owned by the deceased spouse gets that transfer of ownership. The other half is already deemed to be owned by the surviving spouse. So is there a transfer sufficient to meet this transfer of an interest requirement to qualify for a 754 election for both halves of the partnership interest that got a step up in basis in the prior slide. In other words, can we take that 1014b6 rule that said there's a deemed transfer to the surviving spouse and have that deemed transfer also meet the requirements of this transfer of an interest under Code Section 743B? And the answer is yes. There's a revenue ruling, 79-124, which involved this exact situation, where there was a partnership interest owned by community property between two spouses, A and B. Now, it was titled solely in A's name, but the community property laws said that technically A is treated as a 1/2 owner and B is treated as a 1/2 owner for both state law purposes and tax law purposes. So, what this ruling held is that for purposes of Code Section 743B, there were two transfers of interest here sufficient to meet that requirement. One was an actual transfer of A's 1/2 interest to A's estate upon A's death, and the other is a deemed transfer of B's 1/2 interest to B technically under Code Section 1014b6. So since both halves had a transfer sufficient here to meet the 743b requirements, the 754 election could apply to the entire partnership interest and not just A's 1/2 interest. The outcome being that the whole outside basis step up for A and B's community property interest could be shifted to their proportionate share of the inside basis of the partnership assets. So the key takeaways here is that starting out, even if you only have one spouse who's a partner in a tax partnership, it helps to double check to see if the interest might be treated as community property under the laws of the state where the spouses live or might previously have lived if they've moved from a community property state, because it preserves this benefit of a double step up, even though only 1/2 of the interest is exposed to estate tax on the death of a spouse. Now remember, I want to bring back in that rabbit hole language I quoted earlier, includable in determining the value of the gross estate under 1014b6. Does this mean that exactly 1/2 has to be included in the gross estate? Maybe not. We don't know. How could that be affected by discounting? And might the IRS force a discount for the 1/2 share included in the gross estate that may not be as great as the discount that might apply to the entire community property share as a whole? And I want to note there that it does not say 1/2 of the value is included in the gross estate, only again that 1/2 is includable in determining the value of the gross estate. So that seems to bless discounting and different values between the 1/2s. So technically after discounting, you might have less than 1/2 included in the gross estate. But that's a subject for another time. But the key takeaway here at the end is that even though there may be no transfer of the survivor's 1/2 interest under community property laws, there's still a qualifying deemed transfer for purposes of the 754 election in the case of a tax partnership. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com with the caveat that I cannot give tax or legal advice in response to your questions. But I thank you again for listening to this video, and I look forward to seeing you in my future content.